Welcome, everyone. Good afternoon. Welcome to Government Liability for Dangerous Roads. My name is Cassie Seaton, and I am the Outreach Director at the Strip Matter firm. Our firm was started 75 years ago in Hoquiam, Washington, and we still have an office there as well as our main office in Seattle. Three of our partners of our firm are former presidents of the WSAJ, and our namesake, Paul Strip Matter, was also the president of the WSBA. A significant portion of our practice involves partnering with other lawyers on major personal injury and wrongful death cases. The WSBA has licensed the Strip Matter firm as a sponsor for mandatory continuing legal education and approved our seminars for credit. You will receive 1 free credit for attending today's webinar. Please stick around at the end of the webinar, at which time attendance will be verified. If you need to leave early, please notify me via the chat. You will find the written materials in the chat. Please save and open the document. I encourage you to submit questions via the question and answer box throughout the presentation. Our presenters today are senior partners Keith Kessler and Ray Kahler. Keith focuses his practice largely on holding governmental entities accountable for dangerous roads with an end goal of eliminating hazardous conditions that jeopardize the safety of the traveling public. Keith is a fellow with the American College of Trial Lawyers and has served as president of the WSAJ, president of the Invitation-Only Damaged Attorneys Roundtable, and president of the American Board of Trial Advocates, Washington chapter. Keith serves on the Washington Supreme Court Pattern Jury Instructions Committee. For 20 years, Ray has focused his practice on a variety of personal injury and insurance claims and handles appellate review. In 2018, he served as Superior Court Judge in Grays Harbor County. Ray graduated magna cum laude from Harvard Law School, where he was an articles editor of the Harvard Law Review. At this time, I'd like to hand it over to Keith and Ray.
Thanks, Cassie. What Keith and I would like to do with this CLE today is to give some examples of things to look for in motor vehicle crash cases, including single vehicle crashes, conditions where the road design or maintenance may have contributed to causing the crash. Keith, do you have any other initial comments before we go?
Sure,
ahead.
Yeah. There are 2 reasons for this CLE. One is to encourage people who are looking at car crashes to look beyond the defendant driver. Take a look at the roadway that was involved. If it's an intersection, is this an area that looks pretty chaotic? Does it appear that there should be a traffic signal there? The idea is that there may be more than one cause of a collision, including an unsafe roadway or unsafe lack of signage. The second point here in Washington, we'll get to this, there's a duty to provide reasonably safe roads. It's our responsibility on behalf of our clients to hold them to it.
Okay, so we're going to look at some specific road design and maintenance issues that tend to come up in motor vehicle crashes, and then some specific case examples to illustrate those. But just initially, we wanted to make some comments about case intake and evaluation. First of all, these are very expensive and time-consuming cases. They're similar to medical malpractice and product liability cases in terms of the number of experts involved and the expenses involved and the time involved in working up one of these cases. And so you need, one initial question you have to ask in looking at these cases is, are the damages significant enough to make a road design case economically feasible to pursue? And then another major issue in these cases can be joint and several liability. If there's more than one defendant, and oftentimes a driver, in addition to a governmental entity, if there's any fault on the plaintiff, then that will destroy joint and several liability between a driver and a governmental entity or potentially other defendants that might be involved. And if you don't have joint and several liability, then you're only able to collect whatever the governmental entity's percentage of fault is if the driver has low insurance limits, and that may make a case not economically feasible to pursue. So a couple of issues to keep in mind on joint and several liability and contributory fault is passengers in a vehicle are almost always fault-free. And a plaintiff who's the favored driver who has the right of way is entitled to a reasonable reaction time after it becomes apparent that a defendant driver is not going to yield the right of way before any contributory fault can be charged to them. One suggestion is to do an early focus group even before filing a case, if there's a question of contributory fault, to assess that risk, because that can be a very important factor. A couple of pointers on investigating these cases. Public records requests can be very helpful in getting information and documents to evaluate a case, and the State Patrol has a tool on their website that will allow you to identify crash history at different locations. And this is the webpage for using that tool. And Keith's going to go ahead and describe the legal standards that apply.
Sure. And before I do, I should indicate that the State Patrol request is the approach to take. Don't bother with the State Department of Transportation. They won't assist you. It's the State Patrol that has the obligation to gather these records and make them available to the public. Let's talk about what the law is in this area, because it's well defined. WPI 140.01 says that the governmental entity has a duty to exercise ordinary care and the design, construction, maintenance, and repair of its public roads, streets, sidewalks, and bridges to keep them in a reasonably safe condition for ordinary travel. In negligence cases, we generally have to establish duty, breach, and injury, resulting injury. So ordinarily, we have to prove a duty existed. And here, in this area of highway design, we don't have to do that. The duty always exists. That's been the common law in the state of Washington since 1895. So the issues in these cases, was the roadway reasonably safe? In most cases, it's not reasonably safe. If it's not reasonably safe, it's the result of governmental negligence or failure to maintain the roadway. There's a key case that I call your attention to, and in the materials relating to the duty on the part of the governmental entity, and that is Owen versus Burlington Northern, which is a major case. Brian Russell, I think, is in our audience. Brian was the plaintiff attorney in that case, and we ended up with a remarkable result from the Supreme Court, where the court said, essentially, if the plaintiff is able to establish an unsafe condition, the duty shifts, the burden shifts to the defense to show what they did to make it the roadway reasonably safe, and which is usually zero, which is why the injury occurred in the first place. And that takes us to what Ray was showing a moment ago, which is 140.0101. This is, in fact, Owen versus Burlington Northern. The duty includes a duty to take reasonable steps to remove or correct hazardous conditions that make the bridge unsafe for ordinary travel, including hazardous conditions that may exist along the road, bridge, and so on. The point being that once you establish that the roadway is unsafe, the burden shifts to the defense to show what they did to repair it. And it's not just, note that it says along the road, it may exist along the road. That's not just the street itself. It's, as we'll discuss shortly, the Wuthridge case holding addresses site obstructions created by hazardous vegetation at an approach to an intersection. So it's not a matter of just the roadway. WPI 140.02 talks about a different situation. This is in conditions under which the governmental entity was not actually responsible, that is to say, did not create the condition in the first place, whether through creation of a road or roadway condition or a curve in the road or lack of signing. It's a matter of snow and ice, essentially. And these cases are very, very difficult, in part because there's a requirement that the state, county, or city have notice of the condition and have a reasonable opportunity to correct the condition in order to be held liable, and that's very, very difficult. It seems as though in the state of Washington that should not be an issue because we have a preventive maintenance program at the state DOT level. There are ways of obviously determining whether or not a roadway is going to be freezing, whether there's going to be the deposition of black ice on the roadway surface, and the use of anti-icers such as calcium chloride are always available to address that issue in advance of a condition having come into existence. So, but snow and ice cases in the state of Washington, I don't know if, Ray, you're going to be talking about that, or if you have, but the bottom line is snow and ice cases are very, very difficult in our state. We are just really behind the power curve there. The last section of the WPI I wanted to talk about is 140.03. And this says a person using a public road has a right to proceed on the assumption that it's safe for travel until he knows or should, in the exercise of ordinary care and know to the contrary. Meaning that there's an assumption that the state or county or city has done its job in providing a reasonably safe road. And that presumption is something that we can use in cases where there's an allegation of contributory fault. And that is, I think, the areas of law that affect us in these highway cases, both highway design and maintenance.
Okay, so now we're going to move on and talk about the first road design and maintenance issue, which is clear zones. And the basic idea with regard to clear zones is that the road side is part of the road. The idea is to have a forgiving roadside where the drivers can recover if they lose control or go off the road for whatever reason. The idea is that they should have an opportunity to recover and not hit a pole or tree or flip over because of a steep slope. On a highway, on a 55, 60 mile an hour highway, typically the clear zone width is about 30 feet. On lower speed, lower volume roads, it's generally 10 feet. But in some situations, because of space constraints, it's not possible to have that design clear zone. So if there are fixed objects in the clear zone, such as trees or utility poles or overpass supports, the standard is that they're supposed to be removed, or if they can't be removed, then mitigated, such as by shielding them with guardrail or some other type of barrier, so that if there are errant vehicles that leave the roadway, they don't strike those objects. And it's a standard part of road design to do a clear zone analysis, to look at objects that are within the clear zone and to document them and to document what can be done to address those if necessary. And then the first example of a clear zone case here is a utility pole that was close to a highway. This is SR 105 in Grayland in Grays Harbor County. And the Public Utility District had done a project in this area where they had moved other utility poles outside of the 10-foot clear zone, but for whatever reason, this pole was not moved, and this collision resulted in the death of the driver. And there are specific standards and regulations for the placement of utility poles, and I'm not going to go into detail on that. We just wanted to discuss the basic clear zone concept. And Keith, do you want to talk about the Lohman versus Wilbur case briefly?
Yeah, Lohman versus Wilbur is also a utility pole case. And it's an important clear zone case for two reasons. One, it reaffirmed the county and the utility company's liability for locating a utility pole too close to the roadway edge. And secondly, and most importantly, it reversed a long line of cases that had held that governmental entities have no duty to provide reasonably safe roads for drivers who've been drinking or driving recklessly. And here, the driver, Wilbur, and her passenger, Lohman, left a bar. They get in the car, and Wilbur's driving, and it's a long two-lane country road near Anacortes. She drives down the steep hill and loses control of the vehicle, leaves the road, and hits a PSA utility pole. The pole is located 4.47 feet away from the roadway edge. And at trial, Lohman presents evidence that Skagit County's own utility pole placement standards required a 10-foot clear zone at that location. Other evidence showed that Wilbur was speeding at the time, and she was driving while under the influence of alcohol. The county argued that it has no duty to provide reasonably safe roads for people who have been drinking or driving recklessly, and they're relying on a number of cases from the Court of Appeals going back a number of years, Bregelman versus Snohomish County, Klein versus Seattle, that held that if a driver is driving recklessly or under the effect of alcohol, that there's no duty arises to provide a reasonably safe road. And the Supreme Court, however, expressly rejected the Court of Appeals argument in Lohman versus Wilbur. The history of Court of Appeals opinions and the county's argument, and held that it makes no difference. Under Keller versus City of Spokane, the duty exists to provide a reasonably safe road regardless of the fault of others, including the fault of the plaintiff. And as a result, the court noted that first of all, it held that a municipality owes a duty to all persons, whether negligent or fault-free, to build and maintain its roadways in a condition that's reasonably safe for ordinary travel. It went on to note in its conclusion that, quote, whatever the reasons for the car's departure from a roadway, as a matter of policy, we reject a notion that a negligently placed utility pole cannot be the legal cause of resulting injury. So now we can take cases where people have been driving recklessly or drinking and that sort of thing, but one needs to be careful given a jury's likely response to that degree of bad driving and trying to hold the municipality liable. Nevertheless, it was a major change in the law and a very impressive job by the Supreme Court, clearly separating the responsibility of each of the defendants.
Okay, and the next two cases are examples of clear zone issues in the median of highways, and Keith is going to talk about those two.
Yeah, this is what is shown as an earth berm, what they call a redirectional landform here, but it's an earth berm. It's an experimental redirectional device. It was conceived in 1971 as an alternative to the guardrail. What it is just compacted dirt, and it's back in 1973, some official with the State Department of Transportation decided that it would be, quote, aesthetically pleasing, close quote, and would, quote, gracefully divert an errant vehicle, close quote, rather than having the ugly guardrails that rust. So they installed these 198 of these across the state of Washington to attempt to protect vehicles from striking overpass bridge pillars. This here was this case here. This is April of 2003. A car's rear tires lost traction on the wet roadway surface of State Route 522. This is the overpass for SR 202. Loses traction, slides into the grassy median. In the rear, crashes into the overpass pillar, explodes, and that is the gas tank ruptures, and the vehicle explodes into a ball of fire. The passenger is trapped in, they've done the jaws of life here, but at the time, the passenger was trapped in the car, and the car burned. What was interesting, according to the State Patrol, they said that this earth berm served as a ramp directly into the support pillar. The argument in that case was, of course, that a guardrail would have returned at an angle of 8 degrees to 10 degrees. It would have returned the car to a 4 to 5 degree exit angle, resulting in no disabling injuries. Unfortunately, that was not done, and the passenger burned to death. Another case, interestingly enough, that was back in 2003. In 2006, we are addressing a similar situation. This is the Center Drive Freeway overpass in DuPont. It's constructed in 1997. Once again, it's supposed to be guardrails or some sort of protection, but they've got the earth berm instead. And so at this point, we've had the fatality we just discussed. There's a triple fatality at Smoky Point. There is testing at the Texas Transportation Institute that shows that repeatedly this earth berm fails to redirect vehicles, and as a result is inadequate and unsafe. So to its credit, the state legislature decided that they better do something about it, and they provided for a 6-year plan of funding to eliminate these earth berms and place instead guardrail or concrete barrier to protect vehicles from making contact with it. However, October of 2013, a 16-year-old driver heads south on I-5 toward the Center Drive overpass. And she attempts to change lanes to the right. There's a vehicle in the right lane. So she responds by overcorrecting, turning sharply to the left. Her vehicle slides across and into the grassy center median, into a utility pole, the overpass pillar. And there's, again, it's only the earth berm. She ends up, as a result of the crash, as quadriplegic. And what was interesting about this case is that it was, even though there had been funding for this project, the State Department of Transportation couldn't explain what happened, why the guardrail or a concrete barrier had been installed, and what happened to the money. They didn't even know what happened to the money. But long and short of it is that we were able to show that a guardrail, in this case, cement barrier, would have redirected the vehicle so that there would have been no disabling injuries whatsoever. And as a result, I guess the thrust of this is that concrete and barriers and guardrails do work in terms of absorbing, in the case of guardrails, absorbing impact and redirecting, and in the case of the cement barriers, at least redirecting and preventing contact with overpass pillars.
The next case is an example of a clear zone issue on the shoulder. This is SR 508 near Morton in Lewis County. And the condition here is a shoulder drop off with a slope that's too steep, which is a hazardous condition in the clear zone because it will cause a driver to lose control. And here you can see here, this marks the location of a culvert down below here. It's just inches beyond the fog stripe. This is a view of the culvert. And then this gives you some perspective on how deep and steep of a slope this is. There isn't sufficient room here to flatten the slope because there's a steep incline, a mountain hill right next to the road. So, but there are options for addressing culverts and ditches like this. And these are this is an example of what's called a drop inlet, which is in the state DOT design manual. And it involves putting a grate over the culvert. You can see the culvert pipe here, and it calls for putting a grate in and then filling the rest of the ditch so that it's a level shoulder area rather than a steep drop off. And this is just an example of a grate that's used in that type of condition. The next, did you want to say anything before we go on to median barriers, Keith?
Well, there was a question about the case that held that the duty to provide a safe road exists regardless of the negligence of others. And that's Kelly versus City of Spokane is the primary case in that regard.
Keller.
Excuse me, Keller. Yeah, Keller versus City of Spokane, right? Okay. That's the key case there. And it's in our materials, by the way. I think we've got about 34 pages of analysis of those cases. So median barriers, yes.
Okay. So median barriers, that it's an issue to consider in any crossover collision case. And it could be Jersey barrier, guardrail, cable barrier. There's also some barrier curb options that we'll talk about, which might be effective depending on the prevailing speeds. There's no hard and fast rule for when a barrier is required, and it's largely a function of crash history. Caltrans, California Department of Transportation, does have a warrant that's often used by other transportation authorities as a reference point. As Keith said, typically in road design cases, you don't have to prove notice of an unsafe condition. There's case law saying that the government is not entitled to a free bite. But this median barrier situation is kind of an exception to that, where you might have to prove a history of crashes in order to support a claim that a barrier should have been installed. And now Keith is going to discuss a case involving a crossover collision and median barrier.
Sure. And we had talked about State Route 522 with that overpass pillar. This is 522, and this is 23 miles in length. All but 3 miles of this highway have this concrete Jersey barrier that you can see in this photo here. But for some reason, and it's primarily political, because these are two different legislative districts, and therefore funding may be requested for one and not for the other. But in any event, WSDOT clearly saw the need to prevent crossover collisions, but left 3 miles worth of the highway without any Jersey barrier. And as a result, the highway itself was referred to even before this as a highway of death. This is in a WSDOT memo. They've referred to it as a highway of death. That's based on the community's complaints. In any event, on this occasion, Stanley's driving southbound on SR 522. His wife Joan is his passenger. The defendant driver is approaching from the opposite direction, heading northbound. It's 3 o'clock in the afternoon. Defendant driver becomes sleepy. His car drifts off to the side, onto the shoulder. He's suddenly awakened by the front of his car striking an orange construction barrel. He swerves sharply to the left, and his car crosses over into Stanley and Jones' lane of travel, and he hits them head on, and they are killed. And a common excuse advanced by the state is that rumble strips down the center line are effective in reducing crossover collisions. It is true that those rumble strips that you see in this photo here will alert a driver who's nodding off that they are crossing over into oncoming traffic, but obviously it made no difference here. This fatal head-on collision was a result of the lack of a guardrail, or the lack of a median barrier during this 3 mile length of the highway. And it's unfortunate because it makes no sense. It was a political decision and a claim that it didn't make the priority array, even though the balance of the highway had.
Okay, and then this is an example of a median barrier case on a lower speed roadway. This is SR 167, also known as Bay Street in Tacoma. There was a long history of crossover collisions in this curve. And you can see in this photograph, there's what's called C curbing in place through some of the curve. That is sloped on the side. It's easily traversable. It's not considered to be a barrier, and it did not do anything to prevent this pickup truck from crossing over the center line on this occasion. There are, as I mentioned, barrier curb options that have been used in the state of Washington. There's some that have been, this is an example of one on a bridge in the city of Aberdeen, but they've also been used in medians in Federal Way area and a few other locations. They have been tested to be effective on lower speed roadways to prevent vehicles from crossing over into the other lane. The next area we're going to talk about are intersections. Intersections are inherently places of conflict because there's vehicles approaching from different directions. And so the issue is how to manage vehicular movement through intersections to try to mitigate and minimize the risk of collisions occurring. The first issue with regard to intersections that we're going to talk about is sight distance. And there's two main types of sight distance. One is stopping sight distance. That's the sight distance that a vehicle needs or a driver needs to be able to stop. And it's a combination of the perception reaction time and the time that it actually requires to bring a vehicle to a stop. It depends on the speeds on the roadway, and there's a table in the MUTCD, the Manual on Uniform Traffic Control Devices, that tells you how much stopping sight distance is required. This is an example of a case where the driver was unfamiliar with the roadway. This is SR3 and Grapeview Loop Road North in Mason County, an intersection of a state and county road. And the driver was unfamiliar with the road, was approaching this intersection, could not see the stop sign, which is off to the right of this curve, and said, "What's this?" Slammed on the brakes, but was unable to stop before going out into SR3 and was hit by a pickup truck towing a fifth wheel trailer. So this was a stopping sight distance issue. The state came along and addressed the issue by putting a second stop sign on the left-hand side of the approach to give more sight distance for a driver approaching this intersection. Another issue in this case was that if you don't have sufficient sight distance to a stop sign, which wasn't possible here because of this curve, then you have to provide a stop ahead sign.
And carrying on in this area of intersection approaches, we've got one of the appellate court cases that we're pretty proud of addressed site obstructions at intersection approaches. That's Wethrich versus King County. Plaintiff is riding his motorcycle along Avondale Road Northeast.
Keith, let me just make a couple other comments on this.
Oh, sorry, Ray.
Yeah, before you
sure.
go on. Yeah. So there's also a table that provides guidance on where to locate a warning sign, like a stop ahead sign. And the basic idea is that it needs to be located near enough to the hazard or the condition that it's warning about to be effective. Otherwise, if it's too far away, drivers will forget about it because of other things they have to attend to while they're driving. And especially for a stop ahead sign, it needs to tell drivers where they need to begin slowing down to come to a stop. And so the issue in this case was that the under the table, the stop ahead sign should have been posted 180 feet before the stop sign based on the speed limit for this road. The actual stop ahead sign was 640 feet away from the stop sign.
And the concern was, of course, that you forget about the stop ahead sign because things have happened since. I think it was like 11 or 12 seconds over that period of time.
Yeah, and one other thing to point out on that case, it involves an intersection of a county and state road. And there's a statute that addresses responsibility between the state and cities for state highways that are part of a city road system. There's agreements between the city and county authorities in the state, but you need to look carefully at those kind of situations. You may need to file suit against both entities in those cases.
And let them fight it out. This, I was starting to talk about Wethrich versus King County. Here, plaintiff, leave it on this spot if we would, Ray, on this photo. Plaintiff is riding his motorcycle along Avondale Road Northeast in King County, which is about where that sheriff's vehicle is. So that's the direction he's traveling. He's approaching an intersection with 159th Street. This is a view from 159th Street at the stop bar. An off-duty police officer is driving on 159th Street, approaching the intersection. She reaches the intersection. She stops at the stop bar to wait for passing traffic. She looks left and right, doesn't see the plaintiff's motorcycle approaching, and so she heads out. The plaintiff motorcyclist, as he enters the intersection, he sees the left front bumper of her car suddenly emerge from behind a wall of overgrown blackberry bushes, which you can see on the left here. The vehicle is directly in his path in less than a second. And the car smashes his right leg and catapults him 46 feet into the air. His head slams into the ground. He's brain damaged, even though he's wearing a helmet. King County Police Detective took a statement from the defendant driver just after the crash. She says, quote, "I was stopped at the intersection of Avondale and Northeast 59th at the stop sign looking for traffic. I sat there for quite a while. I waited until it was really wide open." But as the photo indicates, her view of the traffic on Avondale Road was obstructed by the overgrown wall of blackberry bushes. The King County argued in response to the suit filed against it that its responsibility was restricted to the roadway itself and not to bushes and shrubbery and vegetation along the side of the road. And they said, the county said, frankly, there's thousands of intersections throughout the state where this exists, and one just can't get to it, obviously. It can't possibly be addressed by municipalities if you have to clear site obstructing vegetation at each one of these intersections. But the Supreme Court rejected the county's claim of undue burden and said, quote, "A municipality's duty to maintain its roadways in a reasonably safe condition for ordinary travel is not confined to the asphalt. If a wall of roadside vegetation makes the roadway unsafe by blocking the driver's view of oncoming traffic at an intersection, the municipality has a duty to take reasonable steps to address it," close quote. And to make certain that this meant the government entities did, in fact, have to clear site obstructing vegetation from intersection approaches, the court said, and that's regardless of the number of intersections where this exists, the court said, quote, "In sum, we reaffirm that a municipality has a duty to take reasonable steps to remove or correct for hazardous conditions that make a roadway unsafe for ordinary travel, and now explicitly hold that this includes hazardous conditions created by roadside vegetation." Something to keep in mind when one is investigating a crash at an intersection and the possible causes of it.
And the issue in the Wethridge case, in terms of sight distance, it's what's called decision sight distance, which is the sight distance that a driver, especially a driver that's at a stop sign in this situation, needs to be able to see approaching vehicles from to make a safe decision about whether to pull out into the intersection. But drivers on the main road also need to be able to see, traffic approaching from a side road. And there's also a standard procedure for measuring sight distance for decision sight distance at an intersection like this. And there's also a table for what decision sight distance should be provided based on the speeds. This is a case involving the same kind of sight distance issue on a driveway. This is SR 108 near Shelton. As you can see, it's a 50-mile-an-hour road, and this is a driveway right here. And there's a site obstruction from this embankment that's right next to the driveway. And our client was on a motorcycle going down SR 108. A vehicle pulled out in front of him from that driveway, basically pulling out blindly because of the embankment, and caused a collision. Any driveway like this, whether it's for a shopping center or a private residence, as this one was, has to be permitted by the state. And part of that permitting process includes an evaluation of sight distance. And so this is a driveway where sight distance either wasn't measured at all or wasn't measured correctly. And this, with that embankment there, this driveway never should have been permitted. The next issue with regard to intersections is traffic signals, which is one way to manage conflict at an intersection. The MUTCD has warrants for evaluating whether a traffic signal is appropriate based on the traffic volumes and the crash history. But traffic signals are not always an appropriate solution at an intersection, and both the MUTCD and the WSDOT design manual say that alternatives to traffic signals need to be considered because traffic signals can cause an increase in rear end collisions on high-speed roadways, and in some circumstances will make conditions at an intersection more dangerous. So we'll talk about some of those alternatives that should be considered, but examples are interchanges or grade separation, which is a very expensive treatment for an intersection. But there's also less expensive treatments such as roundabouts or traffic circles. And then we'll talk about J-turns and right in, right out alternatives for intersection design. And Keith is going to talk about this case, which did involve placing a traffic signal.
Right. In fact, In many cases, a traffic signal is going to be absolutely essential for controlling conflict. But as Ray has said, there are alternatives. The problem with a traffic signal is that in some cases, it's as little as $100,000 and frequently $300,000, and often as much as $600,000, depending on the complexity of the traffic signal system at an intersection. So there's going to be always an argument that, well, we don't have the funds for it, and I would suggest that there is an alternative that, for starters, and that is a four-way stop or always stop, depending on how many roads are coming into the intersection, pending proper funding for the traffic signal. This is State Route 2 in Spokane. There's a heavy traffic volume on it with limited gaps in the 5 lanes of eastbound and westbound traffic. The stop bar for traffic waiting on Flint Road, which is a side road, is set back a ways, and it does not allow for easy access in terms of crossing or turning left. The Boeing Company had a facility in the southeast quadrant of this intersection, and they offered to pay for traffic signal for the protection of their employees. WSDOT declined the offer, which was really quite a silly thing to do, it seems to me. In any event, over the ensuing years, we have what are called at-angle crashes, which are crashes where it's essentially T-boning type crashes where someone is hit on the side. These at-angle crashes continue to occur when drivers on Flint Road aren't able to complete their left turns without being struck by eastbound traffic on SR2. So here it's a sunny day in July. Keith and Lisa are riding a motorcycle eastbound on SR2. The defendant driver is stopped on Flint Road, waiting to turn left onto SR2. After looking both left and right twice and seeing what she believed was a break in highway traffic, the defendant driver drives her Jeep Cherokee forward into the intersection and strikes the plaintiff's previously hidden motorcycle. Both Keith and Lisa are knocked through the air and onto the pavement. The Jeep then runs over Lisa and drags her across the intersection. In any event, the Jeep driver tells the officers who respond that a right-turning vehicle had blocked her view of the motorcycle, and it was obvious that the intersection was badly in need of a traffic signal. Responding to our suit against it, the state assert discretionary immunity and lack of funds to afford a traffic signal system. The two lessons here were that, one, discretionary immunity extends only to the highest level decisions of the executive branch. For example, Cougar Business Associates versus Ray, or State of Washington, in which Governor Ray closed the Mount St. Helens to any traffic or business operations. That being a level of the highest, the highest level coming from the executive. That is discretionary immunity, not in the field decisions about whether there should be a stop sign here or a traffic signal there. Second lesson here is a lack of funds is not a defense to tortious conduct, and you'll hear us in our materials that we provided saying that repeatedly. Tortious conduct is not excused by limited funding or budgetary considerations. Anyway, the trial court in this case granted the state motion for summary judgment, declaring that it was immune because of lack of funding, essentially. And we appealed. The Supreme Court granted review. The Supreme Court Commissioner's ruling was that the issue for the court was whether discretionary immunity should extend to, quote, every minor decision related to highway design and maintenance, close quote, particularly where at this intersection, quote, no one at an executive or legislative level ever made a decision regarding whether change in circumstances necessitated a new turn lane, stop sign, or a turn signal, close quote. And 2 weeks before oral argument, the state, this is before the Supreme Court, the state approached and requested that the case be settled, which we did. We settled for just under $4 million. The bottom line is that poverty, they recognize that they were going to lose on the poverty issue, that poverty is not a defense of tortious conduct, and the Supreme Court has stated that repeatedly in a number of cases, and we've got those in our materials as well. In any event, poverty is not a defense to tortious conduct. Budgetary decisions don't make unsafe roads safe.
Okay, this is also an intersection in Spokane. This is US 195 and Thorpe Road. And this intersection, along with others in the same corridor, had a long history of at-angle collisions, as Keith was just talking about, involving vehicles making turning or crossing maneuvers from Thorpe Road here. There had been a lot of residential development, and the traffic volumes had increased substantially over the years. There are a number of studies that describe the difficulty that drivers have making decisions about crossing or turning at an intersection like this, where they have to deal with multiple lanes of high-speed traffic coming from different directions. And there's a large distance that a driver has to traverse to get through this intersection. Stopping in the median is an option, but that puts them in conflict with turning vehicles and is not necessarily a comfortable place for a vehicle to stop there. In this case, the driver intended to go straight through the intersection and pulled out and was hit by a vehicle in the far right lane on the other side, which is a classic type of collision that occurs at intersections like this. And resulted in a triple fatality. One interesting issue in this case was that there were a number of documents in the case, and people had asked for a traffic signal to be installed at this intersection many times over the years because of the history of collisions. And the state's consistent response was that a traffic signal was not an appropriate solution because it would cause an increase in rear-end collisions, even though it would reduce the at-angle collisions. And so as we discussed, there are alternatives to traffic signals that are supposed to be considered. This is an example of what's called a J-turn, which is from the WSDOT design manual from 2007. And the concept here is that the intersection is closed to turning and crossing maneuvers. A driver that wants to make a maneuver like that has to turn right and then go through the median and then make essentially a U-turn. And the idea here is that it simplifies the process for drivers because they only have to deal with traffic approaching from one direction at a time when they're making those decisions. This is an example of the J-turn that was installed at that intersection. This is another example. This is an example of what the state was talking about in that case that I just discussed. This is SR 500 in Vancouver, and it's a high-speed east-west highway that connects I-5 and I-205. It has very high traffic volumes in the morning commute hours, and traffic signals had been removed at a couple of intersections on SR 500, but there were two that still had traffic signals, and this is one of them. What would happen is when the light was red, traffic would back up over a half mile to the east, and there was an advanced warning, a flashing light that on a sign that alerted drivers to the fact that the signal was red and that they needed to stop, but the traffic would back up well beyond where drivers could see that flashing warning sign. And so the result was that drivers would be traveling 60, 65 miles an hour down the highway and suddenly encounter a long line of stopped cars and would be unable to stop in time. And the result was that over 75% of the crashes that were occurring at these two intersections were rear end crashes. So what was done here was to close the intersection and use what's called a right in, right out design. So drivers would have to turn right to get off of to exit the intersection or to get on to the road here, and then would have to travel down to an intersection that was further down and make a U-turn to make a crossing or turning maneuver. And this project was done over the course of a weekend.
Let's talk about channelization as an alternative to a traffic signal as well. This intersection of SR 12 and Maple Street in Burbank, Washington, is a primary route for parents, students, and teachers to access 3 schools on Maple Street. State Route 12 is a 55-mile-per-hour 2-lane highway. The hazard here is that drivers intending to turn left onto Maple Street are often forced to come to a dead stop on the highway because there's no left turn lane at the intersection. So one April morning, Jerry, who's age 16, is driving to school. He stopped on the highway at the intersection, waiting to turn left onto Maple Street. A defendant driver approaches from behind Jerry's pickup and suddenly realizes that he's stopped. And he hits his brakes, swerves to the right, knocks Jerry's pickup to the left and into oncoming traffic where Jerry is hit head on and dies a week later. At issue is the width of the roadway. Is it sufficient to accommodate the installation of a left turn channelization pocket where vehicles waiting to turn left can be out of the line of fire for people traveling up the highway at 55 miles per hour? So again, not every intersection needs a traffic signal. There are a number of alternatives to provide safe passage, and this is just getting a vehicle out of the way.
Okay, then the next topic is road maintenance, and the first issue there is pavement edge drop-offs. There are many studies about pavement edge drop-offs, and just as an example, a 2006 Federal Highway Administration report states when a vehicle leaves the travel lane, pavement edge drop-off poses a potential safety hazard because significant vertical differences between surfaces can affect vehicle stability and reduce a driver's ability to handle the vehicle. The United States Department of Transportation suggests that a drop-off with a vertical differential of 3 inches or more is considered unsafe. Agencies should adopt a policy for shoulder maintenance that includes routine comprehensive sampling procedures and requires prompt remediation of any edge drop-off that meets or exceeds a prescribed threshold. That threshold should be no higher than 2 inches. And the Washington State Department of Transportation does have a policy for routine inspections of shoulders and does consider anything, any shoulder edge drop-off of 2 inches or greater is a condition that's supposed to be recorded as part of a maintenance inspection so that it can be addressed. A classic pavement edge drop-off case is a crossover collision after a driver goes off the pavement, encounters the pavement edge drop-off, overcorrects to get back onto the road, and then crosses the center line. So in any case involving a crossover collision, you should look at whether the vehicle that crossed the center line went off the pavement and whether there was a pavement edge drop-off involved.
And an example of that is this case here, in which a defendant driver was towing a car southbound on State Route 7. The right front tire of his vehicle dropped off the roadway, and we had actually it was a 9-inch drop off from the shoulder, from the edge of the pavement down to the shoulder itself. And when he attempted to remount, there was resistance from the inside of the tire, and then finally he overcorrects and comes across and strikes a motorcyclist with a motorcycle carrying 2 people, husband and wife, and hits them head on, and they both die at the scene. Unfortunately, it's as Ray has indicated, this is classic.
Well, Keith, we're coming up on 1 o'clock here, and I think to stay within the time that we have allotted for this, I don't think we're going to be able to cover everything that we had on the agenda. So maybe to allow some time for questions, maybe we should do that at this point.
Sure. Although we've got more if there are no questions.
Okay. Yeah. Okay, if there's no questions, then we'll go ahead and talk about another example here. This is another pavement edge drop-off case. This is an on-ramp for SR 14 in Vancouver. And the on-ramp in this case wasn't that old. And there was supposed to be an 8-foot paved shoulder according to the design plans, but for some reason the road was either not laid out correctly or not striped correctly when it was constructed. Our client was on a motorcycle going on a ride with some friends. One of the friends got stopped at this light back here, and so he was going to pull off onto the shoulder to wait for the friend to join them. And when he pulled off onto the shoulder, encountered this over 6-inch deep drop off and lost control of his motorcycle and crashed.
Might note, if I could, Ray, that it's evident that the state DOT knew what the problem was because they had striped around the drop off. Notice the fresh white paint for the pavement edge for the fog stripe.
And then the last, that's an indication of where the motorcycle tire rim hit the drop off. The last case Keith is going to talk about is a roadside maintenance case.
So plaintiffs are driving southbound on SR 202 near Redmond. Their right front tire encounters standing water on the roadway and it hydroplanes. The vehicle, as you can see, spins counterclockwise and into the path of an oncoming vehicle. The cause of the standing water on the roadway and the hydroplaning was the failure to maintain brush that was coming up, vegetation that was coming up from the roadway edge. Had it been cleared as it was required for roadway maintenance, roadside maintenance, the water would have dropped down into the ditch and there would not have been standing water there.
Okay, and then we have one more example of a road maintenance case. This is the Chehalis River Bridge in Aberdeen. The bolts that anchored one of the light poles on the bridge had rusted, and in high winds, the light pole crashed onto someone's windshield. All bridges are supposed to be inspected on an annual basis, and there's a checklist form for doing a bridge inspection. And part of that inspection includes looking at the light pole condition. And it looks like there might be a question, and I think that's probably where we're going to need to stop for today, and we may have to come back and talk about bicycles and motorcycles and pedestrians. Was there another
Yeah,
question,
right there.
Cassie? Is there?
Brian Smith. If notice is not required after establishing that the roadway was dangerous, what evidentiary fight should we anticipate in motions in limine regarding notice evidence? Is that something that is always beneficial to the plaintiff? I'm finding in a road design case I have that there are plenty of crashes at the subject intersection, but they are not necessarily that helpful because they're not terribly similar in terms of how similar they are to my crash. Well, similarity it does play a role, for sure. Just rereading the question again. Yeah, no, notice, again, there doesn't have to be notice of a problem. I mean, it's always beneficial to say that they knew about it or should have known about it, but it's not critical. It's not, and you'll find that in the ordinary course of inspecting roadways, and there's regular inspections that are undertaken, that, there's not an excuse for missing something that they should know about. But notice is not required to establish that a roadway is dangerous other than in snow and ice cases.
Where it's a natural condition that
exactly
wasn't created by the governmental entity.
Yeah, the fact that the crashes aren't necessarily similar may still cause one to think that the intersection, there's something wrong with the intersection, and that maybe a traffic signal is needed. And my recommendation, I don't know if Ray mentioned this at the outset, I think he did. Best thing to do if you've got a case where you're concerned about the potential for an unsafe intersection or unsafe section of roadway, contact a transportation engineer ask for a recommendation and consult with a transportation engineer or traffic engineer to get their take on whether or not there's a problem, because they're professionals in the area.
Okay, and Cassie, I think just to respect everyone's time and what we have, we probably should stop at this point.
Absolutely. I just asked, and thank you so much, Keith and Ray. That was great. Please write your bar number in the chat so that I can confirm attendance, and then fill out this survey that you received so that we can read that feedback and keep an eye out for other webinars that we'll be hosting. But thank you so much for attending, everyone.